Stay recognized presence of the jury.
Yes, Your Honor.
Defense? Have a seat, everyone. All right, welcome back. Any problems at lunch? No? I have to ask you every time. I warned you about this. I have another question for you. Is it just me or is it getting colder in this courtroom? It's getting a little colder, isn't it? All right, I'll see if I can, yes, I'll see if I can do something about it.
Your Honor, I think sorry, go.
Oh, I'm sorry. Okay. They weren't talking about this, were they talking about this case? Did anybody hear it? Are you the only one that heard it? How many people heard it? Okay. So they didn't say anything? You just heard the name? Okay. State, you want any further inquiry?
No, thank you.
Defense? All right. Thank you for letting us know. I appreciate it. All right. Mr. J, you may cross.
Thank you. All right. Good afternoon, Dr. West. Nice to see you again. And there were some medical records provided in this case of Mrs. Ward's to the attorneys, correct?
Yes,
And you had nothing to do with providing them to the attorneys, correct?
correct.
And in fact, you hadn't really reviewed her records prior to our chance to talk to each other a couple weeks ago, correct?
I've reviewed some of them, not entirely.
Have you reviewed anything additionally since we last talked?
I've gone through the records again.
Okay. So you've had an opportunity to do that?
Yes,
And so you would agree, as you testified this morning on direct, that your records back then weren't necessarily 100% complete?
at the time of the deposition?
At the
or-
time these records were being made in the mid-2000s?
I'm not sure what you mean by complete.
Well, for example, on your first meeting with Mrs. Ward back in 2005, you switched her from Prozac to Celexa, correct?
Right, and I did not mention why I made that change.
Correct.
Correct.
And so when she first came to you, that diagnosis that she brought with her was OCD and anxiety?
Yes, that was the diagnosis. There also had been mention of depression, but she seemed much more anxious than depressed.
And in that first meeting, you didn't have her former records from the other offices, did you yet?
I don't think so, no.
And so this would have been her self-reporting it?
Yes.
And so did you go into any inquiry with her on that first visit as to what was making her either depressed, anxious, or OCD?
I don't recall. I mean, I probably did, but it's not in the records and I cannot remember.
All right. And then you proceeded to go on to change the prescription from Prozac
Yes.
to Celexa that first visit?
Yes.
Okay. And so when you did that, you had not had the benefit of reviewing any of her medical records from her former provider, correct?
No.
Right. And so you don't really know what their basis, if they had a basis at that time, was for any diagnosis of OCD, anxiety, or depression, correct?
No, I probably talked to her and determined it from my history with her.
Okay. But my question is, you didn't review the records to see if those medical providers, had an opinion?
Not that I recall.
Okay. Now, when you did have an opportunity to go through her medical records, isn't it true that she had been prescribed some form of an antidepressant from at least as far back as 1998?
Yeah, sertraline and Prozac.
All right. Well, and what about the Zoloft?
That's sertraline.
Thank
Sorry,
you.
fluoxetine, right.
All right. And so in 2005, when you first prescribed Celexa, it's not like this was her first day of taking an antidepressant, correct?
Exactly.
And in 2009, on the evening that she became deceased, that wasn't like it was her first day taking Celexa, correct?
Correct.
All right. And when patients come to visit you at Emory Clinic, they would fill out little boxes to check mark what possible issues they were having in a wide variety of areas, correct?
Yes.
And there was a section for mental health, correct?
Yes.
And when she checked those off, she would check off anxiousness, but not depression, correct? And not ever suicidal thoughts.
Correct.
And so that is something that occurred from 2005 to 2009. Periodically, she would go through and check these boxes like other patients, correct?
Exactly, yes.
And it was nervousness, anxiety that she would check, not depression and not suicidal ideations.
Correct.
Okay.
Correct.
Now, in addition to the other issues that she also had a thyroid issue, is that correct?
Yes.
And her particular disorder with it made her metabolism a little slower than normal.
She was hypothyroid.
Right. And so as well as that, she would self-report drinking alcohol.
Yes.
And you, of course, were prescribing her a central nervous system depressant, Celexa.
Right.
And so would her thyroid issue, if she's not taking her medication properly on that, also kind of slow her down like a central nervous system depressant?
It could, but her thyroid levels were always normal when checked.
Okay. All right. And so back looking through those medical records then, from time to time, there was some indication that she wasn't being compliant.
There was, in one of my notes, I think that was in the very beginning in 2005.
And was that in relation to the thyroid medication or the other medications?
I'm not sure. I don't think that was delineated in the notes.
Right. They weren't. All right. And then at some point you began prescribing her trazodone, correct?
Yes.
And that's purpose, the manufacturer purpose was as an antidepressant, correct?
Correct.
But you were prescribing it as a sleep aid.
That's how it's used now. It was not as effective as an antidepressant. It was found to be very good for sleep.
And so the
It
answer,
can be used with the citalopram.
so the answer to my question is you prescribed it to Mrs. Ward as a sleep aid?
Yes.
Thank you. All right. Now, we already covered this a little bit, but you were well aware that she was self-reporting to be a regular drinker, correct?
Yes.
And depending on the particular visit, it would vary how much she was reporting, but it was essentially a daily or almost daily occurrence, correct?
Yes.
And it was more than one drink a day, correct?
From 1 to 2 drinks a day, according to her report.
And despite all of this self-reporting of drinking, you still had no fears or qualms about prescribing her the medication you were prescribing her, right?
I did not at the time.
Okay. And so, as we were discussing earlier, you changed her prescription from Prozac to Celexa way back in 2005.
Yes.
So she had been on it approximately 4 years at the time of her death, September 21st, 2009.
Correct.
Now, you testified this morning that you had referred her out to a psychiatrist. Can you point to me or anybody else in the records where that was?
It's in the note of December 6th, 2007.
Okay. And
I
you're
believe.
and you practice internal medicine?
Yes, I do.
And what does that mean?
I'm a general internist. I take care of medical problems, but in primary care, we do a lot of psychiatry also.
Okay.
So it's not uncommon to prescribe these medications.
And what's your working definition of depression?
Well, there's a list of criteria, 9 in the DSM-5, and basically, if you have 5 of them, you can be considered depressed for a period if you had those symptoms for a period of time.
Most
So,
of those symptoms, most of the days over a
depressed
certain
mood,
period of time?
Right. Depressed mood, feelings of worthlessness, sleeping too much.
I'm sorry, doctor, you need to wait till he finishes the
Oh,
question. 'cause
sorry.
The court reporter can't hear both of you. Go
I'm
ahead and
sorry.
repeat the question, Mr. J.
And so you have to have most of those symptoms in most days within a certain period of time, correct?
Right. Yes.
All right. Now, when did you look up what the DSM-5 definition of depression is?
I reviewed it today.
Okay. Back when we spoke a few
because
weeks
Right.
when we spoke a few weeks ago, I asked you what your working definition was, independent of what DSM said. And so, what was
Exactly.
your definition of depression?
Well, I can't remember the exact words that I told you, but depressed mood, feelings of worthlessness, not being able to function, anhedonia, suicidal ideation. I can't remember all the things I mentioned at that
Okay.
time. I know the different
And now
criteria.
you've gone back and reviewed the DSM-5?
Yes,
And would you recognize that as the authority on mental disorders?
it is an authority, yeah.
Right. Now, what was your working definition of anxiety or an anxiety disorder?
Where people are so anxious that they're not able to function, they ruminate all the time, they're not able to, they have a lot of negative thoughts, and so
Have you since reviewed the DSM-5's definition of anxiety disorder?
have not.
Okay, so that's your definition of it, correct? All right, and how about OCD, or obsessive compulsive disorder? Did you have a working definition of that?
I do have a definition of that. That is where you have intrusive thoughts that make you very anxious, and or you have also, in response to that, repetitive actions
Okay.
that control your life, that are necessary to address the anxiety or address some need that you have.
All right. Now, have you gone and reviewed the definition of that in the DSM-5 since we last spoke?
Not.
All right. And you agree that at least a couple weeks ago you said that these terms were kind of interchangeable as far as you were concerned. Is that correct?
They go together. There's an overlap between anxiety and OCD.
And has that changed since we last spoke? Your view of that?
No.
All right. And despite having now reviewed the DSM-5's definition of depression, do you still agree and maintain, as you did this morning, that anxiety was her primary issue?
Absolutely.
Okay. All right. Now, over the morning, you testified that you had referred her out to a psychiatrist.
Yes.
Did she ever go see one?
She did not.
Did you ever suggest that she go see a counselor to talk about this?
I felt that a psychiatrist would probably be better for medication review, and then she could have seen a counselor. Often they're referred from the psychiatrist.
All right. Now, did you ever feel as though she was a danger to hurt herself?
I didn't.
Did you ever feel as though she was a danger to hurt someone else?
I didn't.
And as a physician, you'd be obligated to say something to somebody if you did.
Yes, I would.
And so even in May of 2019 and that last visit in July of 2019, you did not feel as though she was a threat to herself or anyone else, correct?
2009, yes.
Yes, 2009. All right, thank you.
Redirect. May this witness be excused. All right, state. Thank you, doctor. You're free to go. Yes, you may. Ladies and gentlemen, I need to talk to the attorneys for a minute, so I'm going to send you into the jury room so you don't have to listen to that white noise. We'll bring you back as soon as we're done. Thanks. If you want to get some coffee or tea, go. Feel free to warm up a little. Thanks. All right, have a seat, everyone. Did Mr. Ellsworth go get your witness?
I believe he did. Either that or he's making a run for it, Your Honor. Who knows?
It's looking like he's coming back. All right. All right, you can proceed, Mr.
Thank you, Your Honor.
Phil.
Please sit down, Ms. Steinhaus, and if you would state your name for the record, please.
Christina Steinhaus.
Thank you. Now, I'm going to try to move to this quickly and ask you whether or not you knew Diane Ward.
Yes, I did.
Approximately when did you meet Ms. Ward?
Between 2006 and 2007.
During that period, in what environment or what community did you meet her?
Both our daughters showed horses, and we met at a horse show.
Now, after meeting her at the horse show, what became the nature of your friendship or relationship with Mrs. Ward?
We became extremely good friends, best friends after a while.
Okay. Now, in terms of your husband, what's his name for the record?
James Steinhaus.
And did Mr. Steinhaus have any friendship with Mr. Ward?
Yes.
Did your friendship with Mrs. Ward and Mr. Steinhaus's friendship with Mr. Ward result in the couples socializing together and spending a great deal of time together?
Yes.
Other than the horse shows, what other activities did you do with Mrs. Ward?
Well, we'd go to lunch, have ladies' lunch. We'd go shopping. We'd go to horse shows. We'd go to the Horseradish Grill for lunch. So we'd have Saturdays together. We'd go out to dinner. We spoke on the phone every day.
Every day?
Every day.
Would you have a special time when you would call?
About 5 o'clock.
So around 5 o'clock, you and Mrs. Ward would chat.
Yes.
Is this something where you and Mrs. Ward would you're on the phone having some wine, she's having wine too?
Exactly. It was our cocktail half hour.
Okay, and so you would have sort of the cocktail hour together.
Exactly.
Now, did you ever spend any vacations or, any holidays like Thanksgiving together as a couple?
We did as a family.
Now, and which one was that? Thanksgiving?
Thanksgiving.
I want to direct your attention a little bit to the horse shows, and I want to kind of ask you to describe to the court whether there were any occasions in which Mrs. Ward would apparently drink too much and would lash out and become angry and aggressive toward other people.
Not initially. When I first met Diane, she was carefree and happy. But towards 2008 and 2009, she started to drink a lot. She would start to drink late in the morning at the horse shows, and that would continue into the evening. She was also taking medication at the same time. She was under a great deal of stress and pressure from a number of sources, and she began to lose her temper in an aggressive, volatile fashion.
Explain that to the court about what happened.
One evening in late 2008, we were at a horse show. We were at the Conyers Horse Show for a national derby that both of our daughters were riding in. And Diane lost her temper on me. She went after me and got in my face and was extremely aggressive. Rude, mean, called me every name in the book, pushed me. And I said, you have to calm down. This is about children. This should not affect our friendship. So I walked away and did what I needed to do. And a couple of hours later, after the show had completed, I saw two people helping her to her car. She was totally inebriated.
So she had apparently to use so much to drink that she physically had to be assisted or
Oh,
kind
yes.
of carried,
There was no doubt.
not physically carried, but assisted
Physically assisted to her vehicle. Yes, sir.
to the vehicle. Now, she physically pushed you and screamed at you that day?
She shook me by the shoulder. I was sitting in a golf cart with her.
Okay. And you were her best friend.
Yes.
Did she, on that occasion, at that horse show, exhibit any sort of anger and aggression toward any of the other parents there at the show?
No.
Okay. Did she, on other occasions, exhibit anger and aggression toward any of the other parents at some of the other horse shows after drinking red wine?
Yes.
Please tell the court.
We were at a horse show in Aiken in approximately April 2009. And she lost her temper on another parent publicly at the side of the show ring, at the side of 3 different show rings, pushing this woman, shaking her finger against her eyeglasses, and verbally assaulting her for about an hour and 45 minutes.
Prior to that, had you seen Mrs. Ward consuming red wine?
Yes.
How much red wine was she consuming prior to this incident, this aggressive incident?
I don't know. I assume the incident happened around 2:30 in the afternoon, and if she started drinking at 11 or 11:30, it's anyone's guess.
Okay. Now, have there been other instances in which she has shown verbal or physical aggression toward others at the horse show after drinking red wine?
Not that I have witnessed.
Okay. Now, has there been an occasion at one of the horse shows in which you might have seen her in the morning, say around 11 o'clock, and then had an occasion to see her some 45 minutes or an hour after that?
Yes.
Tell us about that, please.
I believe it was the following weekend, and we were sitting in the exhibitor's tent We got there at about 11 o'clock. The caterers were setting lunch. The bar was open. Diane had a cooler with her with wine in it, and we sat down and had some fruit. She had a glass of wine, and I excused myself about a half hour later and said, I need to go to the ring. I need to get some work done. I'll be back. And I did. I came back about 45 minutes later, and she was sitting at the same table in the same spot with her head on her arm, and her eyes were like roomy. And I said, what's the matter with you? Diane, what's wrong? What did you do? And she said, I was drinking wine. So I didn't want another incident to happen. So I asked her very politely if she wouldn't mind leaving the horse show with me. I took her in her car back to the hotel. I took her to her room, and I told her I'd be back at 5 o'clock and we could go to dinner then. And I left with her vehicle so she couldn't leave.
Now, what year was that?
2009.
Okay. Now, in the horsing community that would go to the horse shows, were you aware of whether Mrs. Ward had a reputation for being aggressive, both verbally and physically aggressive, toward others after she drank red wine?
Possibly.
Well, what do you tell me about possibly?
Well, I don't think anybody would want to cross her after she was drinking red wine for a while. I think everybody was careful about what they spoke about to her.
My question was whether or not the people in the community were talking among themselves about the incidents that you have described here and formulating an opinion about her reputation for being aggressive and violent after drinking red wine.
I understand, and yes.
Okay. And what was that? What was that? What was her reputation?
That she would lose her temper when she was drinking red wine, and she didn't always see the situation in a reasonable fashion, a reasonable or rational fashion that she would have before she was drinking red wine.
Would you see, as her best friend, occasions in which she would appear perfectly or relatively normal, and then very shortly thereafter have a dramatically different reaction, which could be irritable or aggressive or even potentially violent?
The last situation I told you about at the exhibitor's tent, there's no way that she could have, in my mind, there's no way that she could have been as drunk as she appeared in a 45-minute period of time. I don't think she could have drank enough alcohol to become slurring her words, and her eyes were drooping, and she was having trouble walking. This happened between 11:30 and 12:30.
Okay. Now, were you aware of any difficulties or troubles that the Wards were having with a particular bonding company regarding Mr. Ward's business?
I was aware.
Tell us about that, please.
There was a bond company that was coming onto their property in Atlanta and peering through the windows, taking pictures of Diane in her nightgown in the early morning hours when she didn't expect it, invading their privacy, taking their cars. I believe they might have had to go to court to get their cars back a couple of times, and it was very, very upsetting to Diane.
Well, let me ask you this. Did she express to you, either in person or over the phone, her anger towards...
Oh, yeah.
Well, tell us
She
a little
sure
bit
did.
about that, just how she expressed to you.
She was indignant. Of course she would be indignant. And she had a saying. She'd go, I'm going to get the gun. I'm going to get the gun. I didn't take that as she was going to get the gun, but she did. It was something that she said when she felt out of control and where her space was invaded.
So this is in 2009?
And 2008. This was longstanding.
So in 2008 and 2009,
Yes,
your testimony is that when Mrs. Ward would become frustrated, angry, and felt out of control, that she would say to you, "I'm going to go get the gun."
I'm going to get the gun. Not I'm going to get the gun. I'm going to get the gun.
I'm going to get the gun.
Yes.
Now, when she said this to you, was this in person or was it over the telephone?
I would say most always on the telephone. She'd call me after an incident. I wouldn't be there, obviously, or they wouldn't be snooping in the windows if there were somebody else to witness that. So she would call me and say, "I can't believe this. This is ridiculous, Christina," and tell me the story and go, "I'm just going to get the gun. I'm going to get the gun."
How many times did she say on these occasions that I'm going to go get the gun?
Maybe once or twice in the conversation. It was said in an emphatic way.
Okay.
She was mad, I mean, and angry, and who wouldn't be, rightfully?
Now, when did you ever see Mrs. Ward with a gun?
No,
Do you know whether she ever target practiced or did any of that?
not to my knowledge.
And you were her best friend, you had no knowledge of that.
No, I had no knowledge of that.
Did there come a time when Mrs. Ward was to essentially move her material, although the house remained in Atlanta, move her material principally down to Florida for residence?
Yes,
Did you talk with her about how she felt about that?
many times.
And what was that?
She was very upset about making the move. She did not want to go.
Would you help her, or were you involved in a process where she had to kind of go through her stuff, decide what was going to stay and what had to go?
We did clear out a storage area that had some old furniture in it. We did that together. She called and asked me if I would bring my truck and help her because her husband wanted the storage area cleared out.
Now, did you have or either meet with her personally or over the phone days before she traveled down to Florida, which would have been, a few days prior to her passing?
Yes, to answer your question, I had lunch with her the day before she left
So, and that was in Atlanta?
at the Horseradish Grill in Buckhead.
When you got there, was Mrs. Ward already there?
Yes,
And was she drinking?
she was.
What was she drinking?
Red wine.
Did that surprise you?
Yes, it did.
Why?
She stopped drinking red wine for quite some time because it had a peculiar effect upon her. And she began to drink Prosecco instead. And that day was the first time in a very long time that I saw a bottle of red wine on a table at lunch.
Did you ask her about it?
I did.
What did you say?
She said, "I think I'll be fine."
So during that discussion, I think you indicated that she expressed disappointment about having to go to Florida.
She was upset. There was no question. She didn't want to leave Atlanta. She didn't want to leave Buckhead, her home. She didn't want to leave her friends. She didn't want to stay down in Florida where she didn't know anybody.
Okay. Well, did you help her pack up? Did she pack up the dogs, the cat, and the bird?
She did. She had people help her.
And were you speaking with her as she was driving from Atlanta down to Florida?
I did speak to her 3 times while she was driving.
Was she happy about going while she was driving down or not?
No, she wasn't happy. The dogs weren't happy.
Did you plan on going to visit her at any time in the near future after she had gone down to Florida?
Yes.
And when were you going to go visit her?
I was supposed to be there the Wednesday after she died.
So you were to have gone to visit her on September the 23rd, 2009.
Correct.
So a few more quick questions. Were you aware of Mrs. Ward's habit concerning how she handled her medications?
Yes, I was.
Did she have sort of the pill boxes that she would put her pills in and take them daily, or did she have a different procedure?
Well, I encouraged her to get one of those nice containers to put her pills in. But she didn't. She kept her pill bottles in her pocketbook. And if we were driving together, she might ask me to get a bottle out for her. She couldn't always remember if she had taken her medication or if she hadn't taken her medication.
Well, if she didn't remember, then how would she react? What would she do if she didn't have a specific recollection?
She'd take another one.
She would just take some more medication?
Yes.
Did Mrs. Ward express to you any feeling or philosophy about whether if one pill worked, then another pill would be even better?
I believe that Diane was naive when it came to medication. I don't think she took it all that seriously. And I think she felt if one pill was going to help, the second pill was going to help more.
Okay. Now, did you speak with, you indicated that you would speak with Mrs. Ward around 5 o'clock every day.
Yes.
And did you do so on September the 21st, 2009?
I did.
Now, do you remember what that discussion was about?
I do.
And essentially or briefly, what was that about?
Well, we were talking about a horse show, Capital Challenge. We were planning on, we're making some plans to travel together up for that horse show in Maryland. Her daughter Sarah was very, very sick, and our conversation was predominantly about Sarah and how sick she was and how Diane was supposed to have a deposition that week, and she was extremely, extremely upset about it and very, very torn because she believed that she needed to go be with her daughter at college. She thought that Sarah was gravely, gravely ill.
Okay.
The school had told her that, and that's what our conversation was about that night.
You talked with Mrs. Ward over the phone virtually every day, correct?
Correct.
Well, could you tell, as her best friend, listening to her voice, whether or not she'd had too much to drink?
No.
How would you, what would require from you as her best friend to be able to tell whether she had had too much to drink?
If I saw her face, saw her eyes.
Just one moment, Your Honor.
State you want to cross?
Am I to proffer my cross, or can I just argue why this doesn't meet evidentiary
You don't
standards?
have to proffer your cross if you don't wish to.
No, thank you.
Right. Ma'am, could you step off the stand, please, and just step out into the hallway? Thank you. Mr. J, you may proceed.
All right, there's several problems here. One is so much of what she has said today is brand new information. That's
I'm sorry?
one. So much of this today is brand new information.
Okay.
That's one issue.
Brand new to what? I don't see her having testified previously.
She gave a deposition,
Okay.
and I believe there was some sort of agreement that as long as people weren't going to be testifying to, we remember when we did this just a couple of days ago when I spoke to one of my witnesses and got new information and I provided it to the defense. That has apparently not happened with Mrs. Steinhaus' testimony. There is a tremendous amount of new information being provided. That's ground one. The second ground is we need to unravel all these layers of this onion that was just rolled into the courtroom. The first issue is, what is a pertinent character trait of Mrs. Ward? The only pertinent character trait of Mrs. Ward in this trial is violence, maybe, because I don't know that we've gone down this self-defense road yet. So there's either 0 pertinent character traits or 1 pertinent character trait. For violence, if there is a specific act of violence, Mr. Ward needs to be aware of it. This proffered testimony today does not meet that requirement. So therefore, and by violence, what I understand what she said about violence would be the pushing of Mrs. Steinhaus during this incident at the horse show. So there's been no proffer that Mr. Ward knew about this specific instance of violence. Then, as far as the other things, aside from having never been mentioned before, the other incident with the other woman getting up in her glasses or something like that, never been mentioned before. But that does not meet the requirements of violence, nor was it put forth that Mr. Ward was aware of this specific incident if it is violent. So the specific instances, we still have to decide what is violence, and then if it is a violent specific instance, was Mr. Ward aware of it? Because specific instances of violence go to the apprehension and fear of the defendant. Now, the next issue is with the reputation testimony, and under the case law, this proffer has not set forth a sufficiently broad enough body of a community to make this reputation evidence. What this came across as, and I can cite the cases, this came across as the opinions of one or two people over one or two incidents, and that is not sufficient under the case law. And if I may sit, I can cite a couple of those cases.
Okay.
Reputation evidence must be based on discussions among a broad group of people so that it accurately reflects the person's character rather than the biased opinions or comments of a narrow segment of the community. Gallo versus State, Gallo, 183, Southern 3rd, 1079, 2015. Todorovich versus Wolfner, Todorovich versus Wolfner, Wolfner, 555 Southern 2nd, 372, 1989. Defense evidence by 3 persons, each having experienced a single unfavorable business dealing with plaintiff, was not admissible on issue of reputation, where the witness had no knowledge of plaintiff's reputation in the relevant community. So we don't know how often these horse show people were getting together. We don't know how broad of a community we're talking about. That was never elicited. So the reputation testimony just hasn't met the requirements for reputation testimony. And again, for whatever reason, we still haven't delineated the pertinent character trait. Did she have a reputation for violence? That would be one thing. Or did she just have this reputation of being a hothead drunk when she drinks red wine, which is another thing. And that's not a pertinent character trait in this case. So I don't think, as this proffer has been laid forth, there's really much of anything Ms. Steinhaus can tell this court that's admissible. And so we would be objecting to all testimony about specific instances of violence, specific instances of being a bad drunk, and the reputation testimony, because the proper predicate hasn't been laid for reputation testimony on the pertinent character trait of violence.
Response, Mr. Gillen.
Yes, Your Honor. I don't know whether she has been deposed or not. I didn't defend her in deposition. If she was deposed in the first trial, I'll tell you this, I haven't read the deposition, so if they have one, then that's news to me. But more importantly, as it relates to their objections, as it relates to the reputation, it is not necessary for the defendant to have knowledge of the underlying facts concerning the reputation, because that goes to the alleged victim, not to the defense. There is the evidence before the court and the jury supports a self-defense argument. We heard it.
Okay, let me stop you. When I asked you this question before the trial started, whether you were raising self-defense, you said not really. Are you now telling me that the defense is raising self-defense as a defense in this case?
Yes, Your Honor. What I believe I said at the time is I said that our defense involved accident and also supported self-defense. I do not believe that when we had this discussion about self-defense, we said that we were not raising self-defense. And in fact, the evidence that has been introduced by the state supports a defense of self-defense. And self-defense is one of the few defenses in which the activities or the conduct of the alleged victim is relevant to whether or not a self-defense is viable. So what we have here, and Earhart talks about the purpose of the evidence of the victim's violent or aggressive character. So we talk about violent or aggressive character. We've had some testimony concerning a violence, but also in terms of aggressive testimony that is clearly here. What we have here
Are
is,
you arguing reputation?
well, I'm arguing that that she should be able to testify to her reputation based upon what she knows, her reputation for Mrs. Ward, and the character trait here has to do with what Mrs. Ward, what changes took place in quickly and rapidly in her personality after drinking red wine that affected her in a different way. And that different way resulted in some instances, violence, in some instances, in aggression. As we talked about before, there's also a situation regarding her daughter being, she threw a suitcase at her. That's a different issue. We're talking about this witness, Mrs. Steinhaus. Mrs. Steinhaus talked about the horse community and we can bring her back up if we have to count how many people are in that community. This isn't just an event that took place in someone's backyard. These are public events where people are out in public and people are watching what happens. So clearly it's going to be more than 2 people or 3 people. It's a large, multi-people there at the event to watch the horse show. And during that, in front of everyone, Mrs. Ward was acting that way. Now, I would cite to the court Melvin v. State, 592, Southern 2nd, 356, 4th District, 1992, where in Melvin, the defendant had asserted self-defense during a murder prosecution, and the trial court committed reversible error by excluding police officer testimony that the victim had a, quote, reputation as a bully, end quote, even though there was no showing the defendant had knowledge of the reputation. That's kind of what we have here. If we have a murder conviction in Melvin that required a reversal because a police officer couldn't say that someone was a bully, then certainly we should be allowed to have the testimony of Mrs. Ward's best friend to say that in that community she had a reputation after she drank red wine of being, potentially violent and aggressive, and she's got the underlying facts to back that up.
Mr. Gillen, the testimony that I heard from your witness was that these incidents would occur after she had been drinking for hours. She said she would start drinking in the morning until the evening, and that it usually, the 2 incidents she described occurred after she had been drinking for hours. And I don't believe that the court has that testimony in this case. What I have is a blood alcohol level of 0.11. The lady from Atlanta, whose name I've already forgotten, I apologize, who testified that she talked to her on the phone when Mrs. Ward said she had to go. The one that was the high school friend. Mrs. Spearman. Right, who said that she was in a good mood, she was cheerful. She showed no signs of slurring her words or being intoxicated. And additionally, I have your client's statement on Channel 13 saying there was no argument, there was no fight anywhere, upstairs, downstairs, anywhere, and no comment from him. He said that 0.11 was her normal blood alcohol level. He said that in a joking manner, obviously, that he and Mrs. Ward's sister would discuss that. That doesn't appear to be the same testimony that I'm hearing from this witness. Can you address that, please?
Yes, I will. Number 1, this witness testified that at 11 o'clock she saw her at a function and she was fine, appeared to be just fine, and then came back some 40 or 45 minutes later. In that short period of time, Mrs. Ward had changed dramatically, had changed into a different person, and was absolutely pounded and could not control herself. So we're talking about a situation here where Mrs. Steinhaus said, that's what she testified to, at 11 o'clock, Mrs. Ward was fine. Then Mrs. Steinhaus has to go off and do something. She comes back, I think her testimony was 40 or 45 minutes later, and she was out of control. So that addresses the court's concern about whether or not there is anything in the record concerning this sudden shift
But hold on, that testimony, unless I'm wrong, and we can have the court reporter read it back, but that testimony, she said there was no way she could have gotten drunk that fast, is what she was saying. She didn't use those exact words. I'm paraphrasing what I recall from that testimony, that it was that in her opinion, she couldn't possibly have gotten drunk that fast or consumed enough alcohol to get drunk that fast.
But the problem is that she was with her at 11 and she was fine.
Right.
She comes back at 11:45, she's blotted. Something happened there, and our position in this case is that Mrs. Ward, when she drank red wine, would change quickly and would change radically. And that is supported by Mrs. Steinhaus's testimony. Second point, the second point the court made was regarding comments that were made by Mr. Ward. It's somewhat, the state's position now is somewhat contrary to the position that they have taken in this case, and I believe took in their opening statement, and has taken throughout this case, and that is, the state's position is that there was a fight or there was some kind of conflict or confrontation between Mrs. Ward and Mr. Ward on the patio, resulting in a broken glass, wine being thrown on his back, and the wine glass being broken. That's their position. And so, but the key thing there is, and this is critical to our position, the key thing there is that is Mrs. Ward being the aggressor. That is Mrs. Ward throwing an object, glass, wine, whatever, at the...
So you want to use the state's argument to establish your defense, which your client says didn't happen?
I can use whatever evidence is, whatever...
I'm just trying to clarify what your argument is.
I can use whatever evidence is in the record to substantiate the point that we're making. If I may have just 1 minute, Your Honor.
Sure. And
again, Gallo, which is the case that's cited by the state, quotes Antoni, A-N-T-O-N-I-E, 138, Southern 3rd, 1064, a 4th District 2014 opinion, to the reputation of the victim for violence is admissible when the defendant is asserting self-defense to demonstrate that the victim was the aggressor and not the defendant. This evidence is admissible regardless of the defendant's knowledge of that reputation. So that's precisely that citation, Antoni, as well as with Melvin, which was a reversible error case, compels, in our view, the admissibility of her testimony concerning what happened to Mrs. Ward when she would consume red wine. And also, I might add, the testimony in here which gives credence to that is the testimony by Mrs. Steinhaus that Mrs. Ward would react or did react in a way when she was frustrated and felt, quote, out of control, that when people would come around the house taking the cars, taking photographs, what did she say to her best friend? I'm going to get the gun.
Mr. Gillen, I can tell you right now that that statement is not admissible. There is zero evidence that Mrs. Ward was frustrated, upset, or out of control that day. The statement about I'm going to go get the gun is not admissible.
Well, I would suggest that it should be admissible for the court to consider whether or not Mrs. Steinhaus can testify about her reputation. It's consistent with, and you know, one of the components that was raised by the state the other day is that, well, maybe she was in a bad mood, maybe she would scream at people. That's one thing. But if you're reacting in a way where you're saying, I'm going to go get a gun, that's quite different than simply saying, I got in somebody's face and argued with them. So we've added a number of different layers here to this, Your Honor, so that this testimony is admissible. One, the statement about the gun. Two, as I mentioned, the testimony about physically touching people, screaming at people, breaking in a way.
Two people.
Well,
Mrs. Steinhaus and the other lady whose name I don't remember.
Sandra.
Okay.
Well, that's two people, and that then being viewed by others creates the reputation. So we've got, you know, and that's a lot more, Your Honor, just to be very candid. In Melvin, they reversed the conviction because the police officer couldn't testify that the man had a reputation as a bully. I mean, what does that mean? That somebody is a bully? That's not a reputation for doing some physical act or that he would stab people or shoot people. It's just that he had a reputation as a bully. And that required the reversal of a murder conviction in Melvin. So we would argue that all of this should come in. The underlying facts concerning the horse shows, the opinion evidence, and certainly, in our view, the statement by Mrs. Ward in 2009 that when she felt out of control, that she was going to go get the gun.
The statement about the gun is not admissible. I will not allow her to testify to that. The rest of it, I'm still thinking about. Mr. J, your response? And which part of this is, are you asking for a Richardson hearing on the rest of it, if we need one?
I'll deal with that. I've heard her, quote unquote, deposition now.
Okay.
But we're still blurring this whole thing. I didn't stand up here 5 minutes ago and argue that reputation evidence requires his knowledge. I never said that.
I understand that.
And so, again, the question becomes, what is the pertinent character trait? And it has to be only violence, not that she gets cranky, fussy, feisty when she drinks red wine. And the one specific instance that we have of violence is this new testimony that she pushed Miss Steinhaus. Now, I have no problem with that coming in because that's what the evidence code says if Mr. Ward knew. And thus far, there's nothing that says he knew. So as the proffer has come forth, and now this is a motion in limine, I am moving to exclude that because the proper predicate for that specific instance of violence has not been made.
There were two instances of pushing. Mrs. Ward and the other lady whose name, I don't even know if she said the other lady's name.
And
Not
I don't know
Mrs.
that it was
Ward.
pushing. I remember getting up into her glasses and being really close. But again, Mr. Ward has to know about that for a specific instance of violence to be pertinent. Now, as far as the reputation testimony, again, our objections are simply twofold. One, the reputation has to be specifically for violence. They blurred it during their proffer, whether it was violence or whether she's a jerk when she drank red wine. And so since being a jerk is not a pertinent character trait and being violent is, there's a problem that the state is saying that exists. Then the second problem is there has not been a sufficient predicate laid for the body of people in this community and the reputation being widespread. I mean, basically the way it came across was no details. And no details isn't the proper predicate.
Your Honor, may
I have notes on two people being pushed. One was Mrs. Steinhaus, and the other one is this unnamed person who was pushed on the incident where she said that Ms. Ward started drinking at 11 a.m. and then the incident occurred between 2 and 2:30 in the afternoon. Those two incidents of pushing meet Florida's standards of a prior act of violence. But there is no testimony that Mr. Ward knew about either one of them. So at this point, you have not met the standard for self-defense. He knew about it. And then the reputation, I agree with the state. The proffer on the reputation doesn't give me a community. All I have is Ms. Steinhaus, this other person. It appeared, this is just an impression I got, that all of this occurred in Atlanta, not here. But I could be wrong about that.
Well, Your Honor, then I'd like to call Ms. Steinhaus and ask her how many people were there. This is an important matter. We'll call her and ask her how many people watched what happened at the horse show. So if that's the problem, that can be handled very quickly. Because it wasn't in Atlanta, it was in Aiken, South Carolina.
I don't know. That's what I'm saying.
I'm just
you
saying.
You can call her back.
I'll call her back.
I'm still going to have to address any potential discovery violations once we get done with this. I'm sorry? Absolutely. Sorry. All right, ma'am, you're still under oath.
Thank you.
You may inquire.
I want to follow up very quickly, Ms. Stein. When you testified about these two matters in which Mrs. Ward at the horse shows that she was screaming and pushed you, and then either pushed or in an aggressive way touched another individual. I want to follow up with that. Who was that other woman?
Sandra Porath.
Sandra Porath?
Yes.
Hold on,
And-
ma'am, two things. Spell your last name, please, and then,
S-
go ahead.
Steinhaus.
And now spell this person's name, Sandra
Porath. Porath.
A-T-H. Thank you. Go ahead, Mr. Gill.
Thank you, Your Honor. Now, did these events, first of all, with Ms. Porath, did that take place out in a public area?
It did.
Were other people there?
Yes, they were.
How many people?
I would say there's 600 people at the horse show at a minimum at that time.
The people that were around the incident, how many were around this incident?
At least over 150.
Approximately 150 people were there observing this?
Yes. A horse show has different rings where horses compete in, and each one has a viewing stand or an exhibitor tent. And this particular argument went to 5 rings.
Okay. So the outdoors with over 100 people watching.
At least.
How about you, the incident with you? Was that public?
Yes.
And where did that take place?
That took place at the International Arena at a Conyers horse show.
And how many people were around you and Mrs. Ward when this happened?
50 to 75.
50 to 75 people?
Mm-hmm.
Did people observe you and Mrs. Ward in this?
They ran.
Pardon me?
They ran.
People ran away
Yes.
out of fear?
Yes.
Sustained.
Now, when you indicated that there was did people within the horse community, these people, the 600 or 150 that watched the Ms. Porath interview or incident, and the ones with you, did people within the horse community talk about these incidents as something that was
Yes, it was a
troubling?
hot topic of conversation. It was spoken about a lot. It was spoken about online and throughout our horse forums.
Well, how many people were talking about it? How many people became aware of this? Dozens or 50 or 60 or 100 or what?
Our horse show community is small. Each horse show will range between 600 to 1,500 people, and it's a small world, and everybody knew, without a doubt.
Now, when you say that you're aware of her,
Knowledge, let's put it that way. There was common knowledge that there was problems between Sandra Porath and Diane Ward.
was it common knowledge, and I'll focus it more specifically on whether there was common knowledge about Mrs. Ward after drinking red wine having a potential volatile outburst in terms of verbal and physical aggression?
I believe after those 2 incidences, yes.
Okay.
During that period of time, I believe she began to get a bad reputation.
Well, did you talk to other people about it in the horsing community?
I am not the kind of person that engages in gossip, but people did talk to me about it, yes.
So people that were not involved in the incident but were there talked with you about it, and that's the basis. Is that the basis upon which you have drawn your conclusion about her reputation in that community for aggression or violence after she drank red wine?
I would have to say yes to your question.
Okay. And just on one more matter, have you ever been deposed in this case? Were you deposed earlier, years ago?
No. You mean by...
Did you ever give a deposition where prosecutors sat down and deposed you and asked
No.
you questions? Anything else? That's all I have, Your Honor.
Mr. J, you have any questions you want to ask her?
What's your name again?
Christina Steinhaus.
Okay. And so it's your testimony that you never sat down with lawyers and discussed this case on September 8th, 2011, around 1:30 p.m. at 2050 Marconi in Alpharetta, Georgia, A-L-P-H-R, or A-L-P-H-A-R-E-T-T-A, Georgia, 30005 zip code.
What was the name that you brought up?
Christina Steinhaus?
No, Marconi?
Yeah, 2050 Marconi is, I guess, the address. Alpharetta, Georgia, 30005.
No. I spoke with somebody at my house regarding the case, but I don't believe she was an attorney.
Does the name Robin Wilkinson ring a bell?
No.
Kenneth Lewis?
No. I spoke with a woman. I could look her up on my phone if you'd like. Do you show that I spoke to these people?
Yeah, it shows that you were sworn in and gave a deposition.
I was supposed to testify. Can I say that?
You can.
I was supposed to testify in the previous trial. It's not always clear to me whose prosecution and whose defense.
No, let me intercede here, which I rarely do. Did you ever sit down in a room, not in a trial, where you were placed under oath and lawyers asked you questions about your potential testimony? It would have been in 2011.
I spoke with I believe, an investigator. She was a woman, and she came to my farm and talked to me at my farm.
In Alpharetta, Georgia?
Yes, it's actually Milton, but Alpharetta will work. And then I did speak to, I spoke to somebody at the trial, and but not in Alpharetta.
We'll cross that bridge.
I'm sorry, I really don't.
That's okay. I can call people that were there. So this horse community, did you all have like your own Facebook page or something like that back in 2009?
Well, we all have Facebook.
That's not the question, ma'am. The question is, did the horse group community have like a community page?
There was one.
All right. And did you all discuss Mrs. Ward's behavior on that page?
I did not participate. I did read it.
Did anybody?
Yes.
And how many people discussed her behavior?
No idea.
But you read that yourself?
Yes.
All right. And these horse shows, how frequently did they occur?
My daughter and I would attend between 25 and 30 per year.
All right. And is it always the same people that goes to these shows?
Pretty much. A lot of them. Mm-hmm.
A lot of them or all of them?
Well, not 100%. We all just don't go, here, I'll go to all these horse shows. There's a lot of horse shows. We have a small world. Most of us know each other and have ridden alongside of each other for many, many years.
And so this incident with the other woman that's not you, what exactly did Mrs. Ward do to her?
She lost her temper. She poked her in the face. She pushed her sunglasses against her head, and she pushed her back, and she yelled at her for an hour and 45 minutes.
For an hour and 45 minutes?
Yes.
Okay. And you said how many people were there? 100, 150?
Yeah, probably.
For the whole hour and 45 minutes?
They were moving. This is outside. They were moving from ring to ring.
Okay. And did anybody break up this argument in that hour and 45 minutes?
No. I tried.
Did security get called?
There is no security.
There's no security at this horse show with all these expensive horses and young ladies riding the horses, right?
Correct.
Okay. Anybody call the police?
No.
All right. And so this pushing and face mushing, did that happen at the beginning, the middle, or at the end of this hour and 45 minutes?
All throughout.
So she did it multiple times
Yes.
in front of 150 people.
Okay, let me try and describe this better so that you can understand. There wasn't 150 people standing in a circle watching Diane Ward push Sandra Porath around. we are all showing horses at various rings. This type of thing doesn't happen at the side of the rings. It is considered bad behavior, bad performance. It's considered improper behavior. All of us were embarrassed.
Okay.
They should have been embarrassed.
So how many people actually did see this confrontation? Because
150. As she went from ring to ring and walked around, everybody was like, what?
so she's walking around like next to her behind this other woman, yelling at her and then mushing her every once in a while, mushing her face.
She poked her.
Okay.
She didn't mush her. She
Were you
poked her.
were you there the entire hour and 45 minutes?
Yes, I was, but not directly next to her. I was either on a horse, in a golf cart, or they were standing by the ring that my daughter was going to show in at that particular moment.
Okay.
Or I was behind the barn, where they were also. It started behind the barn.
And now with you, how many people were present between the confrontation between you and Mrs. Ward?
There were at least 50 to 75 people there.
And how long did that confrontation last?
Between 10 and 20 minutes, I had a horse going in the ring. I stopped to say hi to Diane. I didn't stop to get yelled at.
Okay.
I stopped to say hi. I sat in the golf cart and said hi. I saw one of our friends take off from the golf cart because apparently she already knew that Diane was incensed.
All right.
And I tried to explain it. I tried to calm her down, and I said, I'm sorry, I've got a horse going in the ring. You sit here and do what you're doing. And I left.
And so how many people have you specifically talked to about the event between you and Mrs. Ward in that community?
I don't think it needed to be a matter of discussion. I didn't talk to anybody about it. That's an embarrassing situation. That's not something to be discussed lightly.
All right, so the answer is you didn't discuss what happened between you and Mrs. Ward with anyone, correct?
I probably discussed it with Neil Seitz, and I know I discussed it with my daughter because Diane called me the next morning to apologize at 8:30.
Right.
My daughter was with me in our hotel room.
Now, the incident with the other lady, how many people did you specifically speak about with in regards to that incident?
Possibly no one. I considered it out of form, bad form.
All right, no other questions.
No,
Thank
please
you.
let me finish.
Thank you. All right, thank you. Anything else?
I would like to follow up. Go ahead. You wanted to finish your answer.
This is not, we are not gossipers. And for me to call other people and drag this story through the mud like it was already being done by everybody else, I'm not going to participate in that, which is why I left the horse show after I spoke with Diane and at the end of the fight she had with Sandra, and I told her I was deeply disappointed in her behavior and she should never behave that way at a horse show. It's not considered proper. I then got in the car and I took my daughter, my groom, my horses, and I went back to Alpharetta because it was my daughter's junior prom that night. So I didn't have a chance to talk to anybody, and I didn't want to. I was horrified.
Now, you were asked a question about who you talked with. How were you aware, as you testified earlier, that other people were talking about, as a result of this incident, Mrs. Ward's reputation in the horsing community for, after the red wine, for acting out in terms of aggression and potential violence?
Let me see if I can describe that for you. Trainers knew it. Other kids knew it. People that would come to my farm who didn't know who I was, maybe to put their horse there or to look around, would say, oh, did you hear about the Wards? Did you hear what happened at the horse show? And I would turn those conversations off quickly.
Well, you say trainers. So trainers talked, you didn't, not necessarily that you talked to them about it, but other people talked to you about what happened?
Yes, all the time.
How many people talked to you about what happened, either with you and Mrs. Ward or with you and with Mrs. Ward and Mrs. Porthrath?
Over a period of time, in excess of 30, it was well known.
That's all I have, Your Honor.
All right, thank you, ma'am. One more time, could you step out into the hallway?
Yes.
Thank you. All right, a couple of things. As I said, the gun comment's out. Do not ask her about that, and you must instruct your witness that she cannot testify to that. Secondly, there is no testimony from this witness that Mr. Ward knew anything about these incidents. Therefore, all you have left is reputation, which I have 2 incidents of pushing, which qualifies as a prior violent act in Florida, under Florida law. But it's the horse community, whatever that consists of, it's 600 to 1,500 people. So I'm going to let her testify to that in a limited fashion. The question that you asked her on the stand about how Diane Ward took her medicine produced pure opinion testimony from her. I don't think Diane took her medicine seriously. I don't think she understood this. The witness cannot give her opinion. I'm trying to prevent what is going to be a series of objections and a witness who needs some guidance. I don't think she's trying to violate the rules, but she appears to need some guidance on what is and is not allowed in court. She cannot give her opinion. She can't testify to what she thinks of how Diane Ward took her medicine. She either knows or she doesn't know. The 2 incidents that she can describe are the 2 incidents, the one she was involved with and the one that she observed. I cautioned you about the manner in which the questions are being phrased to the witness, implying many other incidents. And I don't know that you even realize that you're in the in the hot seat trying to ask the questions and do a proffer. That you got 2 incidents of arguably prior violence, a push. You cannot expand it beyond that with your questions. And you need to be careful about that. I don't know if you need a few minutes to get yourself together to do the direct on this lady. Now, State, are you requesting a Richardson hearing on this?
I can waive the new testimony, but perhaps we should sort out whether they understand that she was deposed before I have to book airplane tickets for a reporter to come down and rebuttal.
The witness does not appear to realize that she was previously deposed in this case. Unless there's another Christina Steinhaus?
Christina Steinhaus.
Steinhaus, sorry. Too many witnesses, I'm starting to get people's names wrong. Unless there's another Christina Steinhaus who was subject to a deposition, she doesn't appear to realize she was deposed.
And neither do, and I'm speaking because I was the first one to get the file from prior counsel, and there was no deposition. This is news to us as well. We did not know she had been deposed. And I don't have a copy. I have a copy of every single person's deposition in this case. I do not have a copy of her deposition. So,
Mr. Jay, do you have a copy of this witness's deposition?
I can get a hard copy brought over, or if they want an electronic copy, as long as it's under 20 megabytes, I can email it to them now. But they should probably review it before she testifies.
So given the issue with her deposition, do you wish to call another witness
yes,
and get this all straightened out before she takes the stand?
we do. And if Mr. J could email it, that would be, we would be much appreciative.
Okay.
And we will,
Do you have another witness you can call? It's now 3 o'clock.
we have 2 more,
Okay, great.
but they're very short.
That's not a problem. We're here for the afternoon. Tell me when you're ready for the jury to come back in again. This is going to count as the afternoon break, so if the attorneys need a break, tell me now.
We're going to call. We're fine. Ron, what?
Does state need a
What
break?
we'll do,
You're good?
Your Honor, what we'll do is take, now, I want a little bit of clarity from the court as it relates to the medication issue because Mrs. Steinhaus also testified that Mrs. Ward would say to her, I've forgotten how many pills I've taken. I'll just take another one. If one pill is good, then another one is even better. May I get that in? I assume I can get that in. That's not her opinion. That's what Mrs. Ward said.
Go ahead, Jay.
We've had a medical examiner and a forensic toxicologist say that you cannot predict one's behavior based on these medications, what, if any, side effects are present at any given time. So if they don't want to speculate on it based on their expertise, then in addition to the specific instances of character conduct objections, this is way beyond her expertise to opine that I saw on one day this happen, and therefore that is what happened on this day.
Well, I've already excluded that. That I don't want to hear from her because she went off on that tangent on the stand. It wasn't the question you asked her, it was the way she answered that she needs some direction. But how Diane Ward told her she took medication, I mean, we have the medical examiner. Didn't you all call, not you, but the defense called the toxicologist last time to testify to Diane Ward's, didn't they?
Yes.
We did call a toxicologist.
The experts need to address Diane Ward's pill consumption.
Well,
She can testify to anything she saw, but not statements by Diane Ward about, oh, some days I forget I take my pills. And
she cannot testify that Mrs. Ward said, I've forgotten, I'll just take some more. If one pill's good, another one's better.
State would object is that's character conduct. It's specifically prohibited under the evidence code.
you can't get that evidence in under our
And we
code.
would object is not character, it's simply her pattern of conduct. It doesn't, it's not about her
A
character.
pattern
It's about,
of conduct is character conduct in the state of Florida. So
but it just, anyway, if the court has ruled, the court has ruled.
yeah, that can't come in, all right?
So,
And why don't we've had a jury sitting back there now for close to an hour. If we can move forward with testimony, and then anything else we need to address in reference to Ms. Steinhaus's testimony, I'll be happy to do once we've released the jury.
and we'll have to call her tomorrow because it'll take me some time to sit down with her and kind of tell her.
That's fine. I'm just saying, let's call the other two witnesses that you have. When we're done with them, I'll address any issues that you have with further clarification on Ms. Steinhaus's testimony, because there was a lot of testimony.
Yes, Your Honor.
All right? So if we're ready, we ready? Let's bring the jury back in.
You proffered with this witness.
Is there anybody else?
Luke.
Yeah, let me clarify. Who's testifying? And anybody else? I don't remember. I looked at these two witnesses' testimony. We're not going to get a lot of opinion testimony from these two folks, right? And Mallory Ward knows that she cannot testify to the suitcase incident.
That was Sarah, Your Honor.
Okay.
Sorry.
You can talk it. If you hit the button and green light those mics, that'll work too. There you go.
It's now toward the end of the trial that I finally figured out the electronics. What I'm saying is that it's not Mallory, but Sarah, as it relates to the suitcase. She will testify, but not today, and she will be so instructed pursuant to the court's directive.
Okay.
And so what we'll do is we'll call Paula, and then we'll call Mallory, and then if we need to address more issues regarding Mrs. Steinhaus at the end of the day that we can, I will then meet with her and talk with her to get her prepared for tomorrow morning.
All right.
After Mr. Jay is kind enough to forward to us. We have now? We have. Okay, thank you.
All right. Anything else? Let's bring the jury back in. Stay recognized presence of the jury.
Yes, Your Honor.
You're the defense. Stay recognized presence of the jury. All right. Have a seat.
I'm ready, Your Honor.
People become giddy by this time of day. The good news is they've turned up the temperature, so it should be feeling a little better. You may call your next witness, state or defense. Mr. Cromwell, call your next witness.
The defense calls Paula Ward, or Paula Seri.
You may inquire.
Do you state your name for the record, please?
Paula Cardinale Seri.
And Paula, tell the jury how you're related to the victim in this case.
Diane Ward's my sister.
And in your family, what was the order of, as far as age?
Well, we always used to joke about it, but my sister. Ma'am, could you move that mic a little bit closer to you? Closer. Okay, yes, ma'am. Thank you.
And your mom's still living?
Yes,
And
my mother's still alive.
what's her name?
Evelyn
Evelyn Cardinal.
Now, this was your younger sister, and tell the jury a little bit about your association with her. Were you two close?
Yes, we were very close. We, like most sisters, we argued all the time growing up, and then we became best friends.
And you also, how long have you known Mr. Ward?
I've known Bob since their first date. Diane and I lived together in Atlanta, and so from their first date, that's how I met Bob.
Now, you've known your sister a long time, and did you know your sister, did she like to drink alcohol?
Yes.
Tell the little jury about that.
Well, I don't know if it has anything to do, we're Italian, so, wine goes with everything. And red wine, I used to joke it was her drug of choice. She liked red wine a lot.
And after Bob and Diane were married, did you all celebrate holidays together?
Yes, we were always together for Christmas. When I got married and moved away from Atlanta, I moved to Florida, my husband was quite shocked that we went to Atlanta every year for Christmas because I was not going to be away from my sister. So we celebrated almost every holiday together, but definitely every Christmas.
So the main holidays like Christmas and Thanksgiving?
Mm-hmm. Yes, Easter.
Go ahead.
No, those the main ones.
And Christmas, would you mostly celebrate those in Atlanta?
Yes, every Christmas.
And this past Christmas, where did you spend this past Christmas?
This past Christmas, we were in Orlando. We came to Orlando.
And who was with you in Orlando?
My mother, Evelyn Cardinale, my husband, my two nieces, Mallory and Sarah, Bob, and myself. We came here for Christmas so we could be together.
Now, where do you live?
I live in St. Mary's, Georgia, which is just north of Jacksonville, Florida.
Tell the jury how you came about moving to St. Mary's.
When I got married, I moved to Jacksonville. That's where my husband was from. And then shortly thereafter, after several years, I went to work for Bob. He had a land development company. And so I was working at a community north of St. Mary's. At the time, that's where I started.
How many years did you work for Land Resources?
I think from 2001 to 2008 or 9, beginning of 2009.
And did you notice a range in terms of compensation or how much you were making during that time period?
Well, it's real estate, so obviously you're paid in commission. So, as hard as you work, that's how hard you get paid. So yes, the years varied as far as income. In the beginning, the years were very lean. I was new. And, the more that the market improved and the harder I worked, yes, my income did increase.
But if you had to average your income for that time period that you worked for Land Resources, what would would your average have been?
The average over the period of time? It was probably averaged about $100,000 a year. But hourly, I probably made about $5 because
that was going to be my next.
Long hours.
About $5 an hour if you totaled your hours. And there's been testimony about how the market sort of was toward the latter part after 2007 and 8 and 9. Things were really, real estate industry was having problems.
It was nationwide. I mean, you had to be crazy if you couldn't see what was going on in the market. I mean, everybody knew it was all over the news. I mean, all of a sudden, everything was it wasn't just the company I worked for. It was nationwide. Everything was imploding. It was horrible.
And in August, sort of focusing our attention to 2009 summer period, did you have an occasion to visit Bob and Diane at their home in Atlanta?
Yes.
And how long were you staying with them?
I stayed there about a week. It was right after my 40th high school reunion, and so I went back to Atlanta, and I was telling my sister, I went and I had a great time at the high school reunion. I said, we've got to go back because we went to the same high school. And I spent a week there in Atlanta with my sister and her family and my friends.
And during the day, did you have an occasion to spend time and observe Bob and Diane together during that time frame?
Yes.
During that time frame, did you ever observe Bob seeming upset with Diane during this time frame? This is August 2009-ish.
No.
Now, shifting to the next month, you had a conversation with Diane on September 18th, 2009, which was the Friday before Monday.
Yes.
Do you recall that conversation?
Yes, I do.
And did you get a sense in that conversation with her whether or not Bob was upset with her?
No. As a matter of fact, we were all laughing because they had both driven two different vehicles. They drove at the same time from Atlanta to Florida. And Diane had the dogs with them and everything, and they were laughing about their trip down and, the dogs, and she said they kind of looked like the Beverly Hillbillies because they had the cars loaded and everything, and they were just laughing about the trip down.
Excuse me one second. May I, Your Honor?
Yes, sir.
No further questions at this time, Your Honor.
I'm sorry.
All right, you were close to your sister, correct?
Yes.
But she never really discussed with you that she was being treated for any mental illness, did she?
No, she did not.
Or seeing a psychologist or psychiatrist, correct?
No, she never said that.
Now, I think during direct you had mentioned a joke about the Italian family and red wine goes with everything, right?
Exactly.
And you said that your sister liked red wine a lot.
Yes.
Did you ever see her drink too much of it?
No, it's not like she drank too much. It's that she liked to drink red wine, but I never saw her drunk. I mean, but my sister was always happy. I mean, with me, we just always laughed a lot. We were sisters.
Okay. And you said that during the August visit, you were down there for about a week in 2009?
I was up there. I was in Atlanta.
Okay.
Yes.
And when you visited with them, she never mentioned anything about financial concerns or problems?
No.
Right. So as far as you knew, everything was fine and dandy?
I knew there were issues because of there had to be issues because of the business I was in, and I knew there were things, but she and I never discussed business. She never discussed it. It was her thing was always about family, and that was it. We never discussed business. The only time I knew there was a problem was when I happened to call the morning the cars were being confiscated, and I'm on the phone with her, and she says, I have to go. And I said, what's going on? And I hear Bob say, they said they're taking the cars out of the driveway, and I just thought, okay, because I knew that was an issue.
And weren't you also named in some lawsuits as the trustee to Sarah and Mallory's trust accounts in their relationship to Land Resource LLC?
I was the trustee. I don't know what I was, other than being named as the trustee. I wasn't anything else other than the trustee.
And did you understand that these trusts were 10% interest ownership in Land Resource LLC?
Actually, if that was the case, I honestly do not remember. I really do not remember.
And so therefore, you're saying that you don't really remember what your role was as the trustee over these two accounts, correct?
I just thought that, being the trustee was, if anything happened, I would take care of them. I thought that, that would be the trustee's role.
And because you were the trustee and you were named in these suits, you were made aware of how much money was at stake in these lawsuits, correct?
I was,
And it's millions and millions, right?
possibly, because I don't remember how much it was.
No problem. Thank you.
Redirect. May this witness be excused.
Yes.
Thank you, ma'am. You're free to go. Call your next witness. You may inquire.
You state your name for the record,
My name is Mallory Ward.
and could you tell the jury your relationship with the defendant?
The defendant is my father.
And where do you live now, Mallory?
I live in Atlanta.
And what do you do there?
I work at a school.
Now, back in 2009, where were you living?
I was living in Washington, D.C. I was a senior in college.
While you were in college, did you have occasion to come and visit your parents in Atlanta or in Orlando, wherever they were?
I did. Any break that I had, every holiday that I had, I was always home with my family.
If you could give an estimate about how often you would come and see them, just so the jury has some understanding about that. This is 2008 to 2009.
Any holiday, so Easter, Christmas, summer break, spring break. I actually spent 3 out of my 4 spring breaks in college with my mom. Not a normal college student thing to do, but we liked each other.
And you have a younger sister.
I do.
And what's her name?
Her name is Sarah.
And what is Sarah's, one of her passions in her life?
Sarah loves horses, and she was good at it.
And is that something as a family you all would like to do? You go to these horse shows together?
We would. I tried to stay away from it. I didn't love the horses, but my family and I enjoyed spending time together, so we'd go as a family.
And tell the jury about what was your observation of the relationship that your mom and dad had together?
My parents had a very loving relationship. My dad doted on her. My mom respected him. They were great. I mean, it wasn't like leave it to Beaver, but nothing is. But, you know, my parents loved each other, and my sister and I got a lot out of that.
And did your family try to stay together or do holidays together, traditional type of holiday dinners and such?
Oh, always. My mom would cook for days before Christmas. Typical Italian, like my aunt said.
Big Italian.
Oh yeah.
Festive.
Making sauce for days. Good lasagna.
What was your understanding of your business, of your dad's business?
I mean, I knew what he did. I was in college, or I was young, and so I knew what he did. I knew when things were good. I knew when things weren't great, but I was pretty wrapped up in myself when I was in college.
Even though you were sort of, I guess, the Me Too generation, or the Me generation, you did notice in 2009 that the money flow in their family seemed a little tighter?
Oh yeah. I mean, it was pretty obvious that things weren't what they were. But again, I was pretty sheltered from it because I was in school.
Did you know about your father's business bankruptcy?
I did.
How was your relationship with your mom?
We had a great relationship. My mom and I spoke all the time. I called her every day. Like I said, we spent spring break together. I loved her. She was great.
Did you have discussions with your mom about your concerns about your mom's drinking?
Oh, absolutely. We would tell her, you know, maybe you don't need to finish that bottle of wine. Or, you know, you try to bring it up, but you're a kid and you just assume that your parents know what's best for them. And
did you ever talk to your mom that you said, Mom, you should maybe cut back because it makes you loopy?
yeah, oh, she definitely would get loopy.
How about your dad? What was the relationship like How was your relationship with your dad?
I have a great relationship with my dad. I've always had a good relationship with him. I respect him. We're a lot alike. I get my voice from my dad. But, yeah, I mean, no but. He's great. I love him.
Now, going to September 21st, 2009, you spoke with your mom that day, isn't that correct?
I did.
Tell the jury about that conversation.
There were a few conversations. We actually spoke 3 times the day that she died. And she talked, I believe, about going to lunch with my dad and things that they were doing together. She said she was going to get a Facebook. I said, please don't. But, yeah, I mean, I believe that's what we spoke about. It was not recently.
How did you find out about your mom's death?
My aunt called me Tuesday morning, September 22nd, and told me that I needed to get on a flight and come down to Florida because something had happened.
When you spoke with your aunt, what did you do?
I had asked her, and I think it was somewhere along the lines of, is Mom alive? Like, what happened? And she said, I think it was fatal. And I turned to my roommate in college, and I looked at her.
Objection to the relevance in the narrative.
Hold on, Your Honor. Let me check with the team.
Oh, sure.
That was going to be my next question. Anything else, guys? You still love your dad, Mallory?
Yes, I would not be here if I didn't.
That's all I have for now.
Cross.
In those recent days before your mom's passing, had she ever talked to you about an upcoming deposition or something that she was set for?
I don't recall.
Would it refresh your memory to see your deposition?
Absolutely.
May I approach the witness and show her page 9?
You may.
If you would, ma'am, can you read to yourself the beginning of page 9 and read a few lines down until you can decide if you remember or not? Does that help you remember?
A little.
Okay. Do you think she might have mentioned it to you?
I assume that she did. I'm sorry, again, it was a really long time ago.
Understood. You weren't aware of your mom being treated for any mental illnesses, were you?
I was not.
Okay.
Yeah.
Thank you. And you were aware that your parents drank, right?
Yes.
And like you said before, they were good. Every family's good, but nobody's beaver. Leave it to beaver or something like that, right?
Correct.
So is it fair to say even good parents sometimes argued?
Yeah. Sir. Sorry, that was weird.
Yep, is fine, but maybe not in court. And when they drank, would they sometimes argue as well, just because you're drinking, and that happens?
Yes, it happens.
Okay. And they were good about trying to keep away from you and Sarah what it was they would argue about. Is that fair?
Absolutely.
They would do it behind closed doors?
Sure.
But sometimes you could still hear the fact that they were arguing, even though you didn't hear what it was about, right?
My parents never went into a room and closed a door and fought.
I'm not saying fight. I'm just saying
Or
argue.
argue. They never, like, there was never an instance where they're like, let me see you, and they closed the door and shielded us. That wouldn't happen.
Okay. Do you remember giving a testimony on a former proceeding in 2011?
Sorry, I don't. The previous trial?
former proceeding. Let me,
Sorry.
if I could, can I approach and show her page 1288?
You may.
All right, and so let me back it up a little bit. Would they argue in other rooms than where you and Sarah were in?
Possibly.
Okay. And you were aware that both of your parents had anxiety medication because of the financial problems?
I do not know if I was aware that it was anxiety medication at the time.
Would looking at page 17 of your deposition possibly refresh your memory on that issue?
I make no guarantees, but we can try.
All right. May I approach?
You may.
Is that font big enough for you?
Yeah.
I know you're the youngest person in the room. Down here, starting at like line 17, can you read to yourself? Does that refresh your memory?
Again, I'm really sorry. I don't know if I said that at the time, then that's what I was aware of. And it's entirely possible that I did not know that those medications were for anxiety until after the fact.
But you accept that your answer at that time was that they were both taking it because of the business problems?
Absolutely. I wasn't lying, so.
Now, you said that in 2009 you were aware that there was some financial issues going on related to your father's business, correct?
Correct.
And were your parents separating their property out into their individual names, like the Georgia homes to your mother?
I don't recall.
May I approach the witness with pages 23 and 24?
You may.
I'm going to ask you to start with line 22 on page 23, down to line 7 on page 24. Let me know if the font's too small.
Can you get bigger?
No, actually, that's the older you get.
Then yes, I guess I didn't know.
All right. And so, is it true that you were aware that they were putting the Georgia homes in your mom's name because that bond safeguard company was coming after them hard, right?
I suppose so.
And ultimately, you understood that there was an irrevocable trust created on your behalf and for your sister?
I believe I found that out after, yes.
All right. So you weren't going to any CEO board meetings at Land Resource or any of these corporations if the trust had given you a 10% interest in the companies, right? You were like 15?
I think I was 21, actually. But still, no.
Okay. No other questions?
Redirect. May this witness be excused. Mr. J, may this witness be excused.
Yes, ma'am.
Thank you. You're free to go. You have no further witnesses this afternoon, right? All right. You're going to get an early afternoon today. You won't tomorrow or the day after, but you're getting one today. We will start back up at 9 o'clock tomorrow morning. Meet the deputies down in the jury room at 8:45. Continue to tell the other jurors not to make any comments around you, and I'll have a chat with the jury room about that. Y'all have a good evening. Don't watch anything. Don't watch the news. Don't read anything, and don't talk to anybody about this. Thank you. What, if anything, do we need to discuss? State? Before we get to preliminary charge conference. No? Defense?
Mr. J was kind enough to send us the deposition, and I think I figured out the reason why we don't have it, and we never had it. And that is, according to the transcript, the state was being represented by Robin Wilkinson, and the defendant was being represented by Ken Lewis. There was no record of any of Mr. Ward's attorneys being present at this deposition. So, if the prosecution goes out and unilaterally takes a deposition of a witness and doesn't notify counsel for the defense, I don't know what we could have done or should have done. I never had it.
I'm not holding you all responsible for not having it. I just know that there's a notice that a deposition was taken of this witness. And it was clear to me that Mr. J had it.
And it's clear to me that he hasn't.
Right, and there is a notice in the court file that this witness was being deposed. What happened at the deposition? I have no idea.
But
I'll let you all sort that out.
I raise that only to say that it's consistent with the witness's testimony, because a deposition is lawyers for both sides, and both sides ask questions oftentimes. In this particular case, we have the state, former attorneys for the state, not present, and I don't know what the circumstances were around scheduling that or what, if there were any. But what we do know from the transcript is that, according to the court reporter, the state was being represented by Robin Wilkinson, who's used to be an assistant state attorney.
I know who Robin Wilkinson is.
I just want to make the record.
Oh.
And the defendant was being represented by Ken Lewis, who actually was prosecuting Mr. Ward during the previous trial. So what we have is two prosecutors and the witness. She may have thought that was a lady coming up to speak with her.
I have no idea. I'll let you all sort this out.
I'll just say that from time to time, transcripts don't accurately reflect who's representing whom, but given that it was September 8th, 2011, on the eve of this trial, and the fact that it happened in Georgia, I have grave doubts that this was an investigative subpoena that was done in last-minute trial preparation on a witness that was exclusively listed by the defense. But we can sort it out. Nonetheless, it's a sworn statement that I intend to cross-examine her with, and I just need to know if she's going to acknowledge that it happened or not, so that I can arrange for either Robin or Mike Snur or whoever was actually representing the defense, if anybody, to come and testify.
All right. I'll certainly give everyone time to straighten that out before she's called to the stand. Both Ms. Wilkerson and Mr. Snur are local. I think Mr. Lewis still is also. So, Mr. Connell, of course, passed away, so he would not be available. Anything else we need to address before we do a preliminary charge conference?
No, Your Honor.
Have any of you had a chance to look at the jury instructions that were used in the previous trial?
I didn't. I assumed it was long enough ago that there's probably an error with the manslaughter instruction. And
the manslaughter instruction is incorrect.
I started from scratch from the Florida Supreme Court with my 12-page draft.
It includes all the standard introduction to homicide, justifiable homicide, excusable homicide, murder in the second degree. The lesser included crimes requested last time was manslaughter. This is the wrong manslaughter instruction that was given originally. I assume you've updated it, Mr. J. Are you all? Okay. The rest of it appears to be the same. It's just that manslaughter instruction that's wrong. State or defense, at this point in time, are you anticipating asking for any other lesser included?
No, Your Honor.
Aggravation of a felony by carrying a firearm. Justifiable use of deadly force was raised in the last trial. I assume you're raising it again this time based on this afternoon's
Yes, Your Honor.
statements? All right, so that'll need to be in there. You got that one in there, I assume? No, not yet. Okay. This one's changed a little bit because of the stand your ground statutes, but it's in essence pretty much the same.
Occurred in 2009. Should I insert the self-defense instruction as it was read then, instead of trying to discover through research what it was in 2009.
Defense, what's your position on that?
On the self-defense?
The self-defense instruction that was given was the one that was in existence in 2009, 2011. As we know, that one has changed slightly due to the change in the statute.
Right, and we would ask for the current.
You want the one that exists now?
Correct.
So state, I take it you're reserving an objection to that pending?
Pending review of the changes, yes, because the law at the time is what applies unless there is some fundamental error in it.
I don't think it's going to be a huge deal, but obviously I'll give you time for that. So, all right, plea of not guilty, reasonable doubt. That one's the same.
And I asked for the voluntary intoxication instruction. I put that in my draft since Mr. Ward indicated on the interview that he'd been drinking.
Mr. Ellsworth?
We don't object to that, Your Honor.
Okay. No objection to voluntary intoxication. Last time they asked for direct and circumstantial evidence instruction. Defense, you asking for that?
No, Your Honor.
State?
No, ma'am.
All right, take it out. Weighing the evidence. That one seems pretty standard. We're not done with the witnesses yet, so 1 through 5 are obviously the standards. Last time around they gave 6. Has the witness been offered or received any money, preferred treatment, or other benefit? And 7, the inconsistent statement one.
From the defense, Your Honor, we would have objections to 6, 7, 8, 9, because they don't apply. And
did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? You're objecting to that one?
no, we're not.
Okay. For some reason, the last time they broke out expert witnesses, I just normally included as part of weighing the evidence.
That's how it was then.
Yeah, it was, yeah. Was it? I don't remember anymore.
It was. It had its
time.
separate capital letters and all that.
Just put it back in with the rest of it, please.
I did.
We, at this point, defendant not testifying, defendant testifying, we don't know, so I'll leave both those in. Defendant statements. State, are you asking for that one?
No, it would appear to be inapplicable.
Defense, are you asking for that one?
No, Your Honor.
All right, take that one out.
None of these are contributed by the defense.
I'm just reading from what was used last time, which is usually a good starting point.
I'm
here.
reading Mr. J's.
The rules of Mr. J hasn't sent me his yet.
I did.
When did you send them?
A week ago Sunday.
I did not get them.
Miss Bryant said she'd send them to the judge.
Well, I will beat her with a wet noodle when I see her, but resend them to me, please.
I can do that now?
Thank you. Yeah. That probably would make this easier than me having to work off the old ones.
Yeah.
Anything else you all are asking for? There's this, the verdict form was pretty straightforward. There was the special finding verdict form. Because this does carry the minimum mandatory.
I just sent
Thank you.
the only update from what I originally sent them, but I resent them, is just deleting the defendant's statements that we talked about moments ago.
Okay. Anything else that we can talk about now, reference the jury instructions?
We may have a few tweaks, but my initial reaction from receiving Mr. J's proposed jury instructions is that we didn't have many disagreements with him.
These are pretty straightforward
Yes.
instructions in this case.
Yes, they are.
The only issue being the self-defense one right now. And then if you all are requesting any other lesser included, manslaughter is a category 1, but I don't know if you're requesting anything else, so. Yeah, you added possession of a firearm, okay, good. Lesser included. On the last one, on submitting the case to the jury, this is just the little stuff. You need to correct that the exhibits will be sent into the jury room with you, since the gun and the ammunition won't be sent in unless they request it. So just
I know we discussed this morning that we would craft something together at some point, so we can discuss that now or at some point.
y'all ready to discuss it, we can certainly have a preliminary discussion about the gun.
I would just say, I'll say something like some exhibits will be sent back with you, and some will be available for you if you request them, something to that effect.
That's fine by me. Defense?
That sounds okay.
Are you going to have the blank laptop so they can view the photographs, the video, all of that?
Yes, ma'am.
There's a completely blank laptop the state has that gets sent back into the jury room, so they don't have to come in here to see everything. Obviously, it'll be available for defense inspection prior to it going back with the jurors. Anything else that you guys want to talk about today? Mr. Jay?
Would the court permit, maybe it would make it easier if we had minor comments on some of Mr. Jay's.
Oh,
Could we send both of you Mr. Jay's version with our comments embedded?
Absolutely.
Okay, we'll do that.
Most of this you all can work out between yourselves, but sure. I have to have the charge conference on record, so and in Mr. Ward's presence, which is what's happened today. I think I actually didn't say this today, which is astonishing, but Mr. Ward and his attorneys have been present throughout the proceedings today, as has the state. Anything else that we need to discuss in reference to the jury instructions at this time?
Not at this time, Your Honor. I'm back to defense.
No, ma'am.
Anything about trial, witness, anything at all that you all want to talk about prior to tomorrow?
Christina, we're going to bring her in. We know she's coming. No, excuse me, Christina. Bring it up now.
Your Honor, we may have a witness that we want to bring in that was not previously disclosed to Mr. Jay. We learned about her this afternoon, early afternoon.
And who might that witness be?
This is going to be an accountant who will testify that, in her proposed testimony is that Diane Ward was aware through her that there was a $20 million life insurance policy on Bob Ward's life. That's the only thing she will testify to.
Mr. Jay? Do you need a minute?
Yeah, I'll obviously need to think about that and get back to everybody tomorrow.
Okay.
And for the record, we will be happy to give Mr. Jay her telephone number right now, and he can call her and speak with her. And she'll obviously come down and be available to be posed. If we'd like to call her tomorrow, we can call her Wednesday if necessary.
How did this information come up?
We, I believe, thought that there was another witness who was going to testify to this, and then we were doing trial prep. That witness properly advised us that that's not something they could testify to, and as a result of that, we scrambled to get another witness.
And that came about this afternoon?
The calls were made to the what's the name? Chrissy Pierce, and the calls were made to Miss Pierce, I would say late morning, early afternoon, and I believe over past the lunch break was when she said she could come. And it was my intention to go talk to Mr. J before this, but I got tied up.
Okay. I'll let you think about it, Mr. J, which means I need to see everybody at 8:30 tomorrow morning, not at 9, because I have a jury coming back at 9. What time would you intend on calling this witness?
This is a witness that we have, the order does not matter to us, so that we would be amenable to any time during the day that the court or Mr. J prefer.
Why don't we meet at 8:30 and see what of this we can iron out?
I can tell you it's a major, major problem. That is going to create a harsh, probably, there's nothing the state is going to be able to do during the defendant's case in this trial that has had this potential information being relevant for 9 years. The state's theory of this case does not involve first-degree murder, life insurance policies on Mrs. Ward. I can tell you there is absolutely no way I can possibly gather, and I've tried over the months putting my toes in the water with all sorts of different attorneys that had all sorts of different information about their finances, but to put that life insurance policy, if it's valid, into any context whatsoever would require all of their finances. And I cannot do that this week. Here we are during trial. How can I possibly actually get all of their books about their finances for the last 4 years and make any sort of indication as to what is Mr. Ward's property, what is Mrs. Ward's property, what is tenancy by the entireties, what does Georgia's state laws on this, where was this insurance? I mean, this is nothing short of pretty crazy to expect the state to be able to rebut something like that on day 2 of the defendant's presentation.
Your Honor, I respectfully disagree with that. In the last trial, Professor Davis from the University of Florida Law School came in here and testified about everything Mr. J just said. And we were going to present this evidence again through Professor Davis. The only issue was, who's going to testify that Bob Ward knew about this? We're not, the only thing that this Diane Ward knew about, I misspoke, Diane Ward knew about this. The only new information we're bringing in that wasn't absolutely addressed from head to toe last trial is that Diane knew. That's it. We're not bringing in new financial information. There's no new information. The fact that the $20 million policy exists came in the last trial.
But the knowledge of Mrs. Ward of that policy would not be a minor issue in this trial.
However, it's not a complicated issue.
Are you saying that you're not, was it Professor whatever his name was?
Davis.
I'm sorry?
Davis.
Davis. Did you all call him?
In the last trial, yes. And we're calling him again tomorrow.
Okay. Let me just say, to say that Kirk O'Connell and Mr. Snurr cherry-picked an infinitesimal speck of sand amount of the financial records to turn over to the state, it fits inside a little copy box like that high. In the research that I've been doing on this case over months and months, the thousands and thousands of pages of documents just on the bankruptcy pleadings, never mind trying to track down all the different civil lawsuits, much less getting discovery. I haven't even been able to get Mr. Ward's interrogatory answers. So if we're going to jump into this Pandora's box about life insurance policies and motive to kill, it is completely unfair to say that the cherry-picked documents that were provided to the state during the last trial in any way will help me on this issue of life insurance policies and who's getting what, and the value of their individual estates, the value of the marital estate, the various states that have different laws on this, it's really, really a problem.
Who testified to the existence of the policy last time?
Professor Davis.
So all of this testimony would be contained in Professor Davis's testimony
That's correct, Your Honor.
for the last time.
Yes, Your Honor.
Right. We're going to conduct a Richardson hearing starting at 8:30 tomorrow morning. This is not a minor issue. The knowledge that Diane Ward may have had is not minor. So we're going to have a full-blown Richardson hearing on this issue tomorrow morning. I don't know what you've seen or not seen. I don't know what was turned over or what you all turned over. So I'm going to need all of those details for the Richardson hearing tomorrow morning. And are you saying that this witness is someone you intend to call?
Yes, Your Honor.
To say that Diane Ward knew about this insurance policy?
Because the witness told her.
A fact that was not introduced in the original proceedings, correct?
That would be the only fact that would be introduced. That was the existence of the policy and maybe it's not all the financial information, but as the court knows, both sides were sort of...
Hold on, Mr. Ellsworth. Who is the person that told you about the existence of this witness?
Who is the person that told me about the existence? I guess that was... Paul, sorry. Told our counsel, not me personally.
Ms. Sarr?
Yes.
The sister of Mrs. Ward?
That's correct.
And did she have an explanation for why it took her 9 years to tell you all, 9 years to tell you all about this?
Your Honor, I will tell you this. The defense team, first of all, the $20 million policy came up in the last trial. As we're preparing, and again, what we're finding in this case, in this courtroom, is that just because it happened, just because it was admissible in the last trial, doesn't make it admissible in this trial. And that's something that has come up a number of times in this case, in this courtroom. And we're not begrudging that. We find that to be correct. Your Honor has made her own rulings and has not been bound by rulings that the predecessor judges have made in this case. So in preparation, and I don't want to get too deep into the defense mind in terms of the legal team, but when we're reviewing Professor Davis's testimony, it was discovered, well, who's going to say Diane knew about this? Because even though all this came in the last trial, we have a new judge and we have a new courtroom. So we then circulated and said we believe there were a few people we believe knew that were already on the witness list. We went and spoke to those people. They did not know. So we scrambled to find someone who did know. And when we found someone, we immediately notified the court.
All right, Richardson hearing, 8:30 tomorrow morning. Anything else?
No, thank you, Your Honor.
No?
That's
All
enough.
right, thank you. Have a good evening, folks. Court's in recess.